Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So what a great way to end the week. We've got some huge breaking news in regards to Duncan v. Bonta, a case that started in the state of California by the CRPA and has since gained national attention for its potential to end mag bans across this country. So we need to talk about what's going on. Let's get to it. Okay, so let's go ahead and talk about what's going on here with Duncan v. Bonta, a CRPA case that I've been covering on this channel now for the better part of a decade, since it was first filed, I believe, back in 2017. So for the past 8 years, I have been doing updates on Duncan, and let me tell you, it's been a little bit of a nightmare up until this point. So Duncan is a case, again, out of the state of California that challenges California's ban on magazines that can hold more than 10 rounds. This is a case that's been bounced around back and forth throughout the court system. We had Judge Benitez give us an injunction in this case that was the cause of California's original Freedom Week, right? A 1 week period where people in California were able to get whatever capacity they wanted. That was eventually shut down. It goes up to the Ninth Circuit Court of Appeals. It gets sent up to the Supreme Court where they kind of held it until Bruin was decided, and then it got kicked back down to the Ninth Circuit, who instead of rehearing the case at the Ninth Circuit level, decided to kick it all the way back down to the District Court level, where Judge Benitez once again found that it's still unconstitutional. Nothing had changed about that, sent it back up to the Ninth Circuit, where eventually the Ninth Circuit found, well, that they don't believe that magazines are even protected by the plain text of the Second Amendment at all. So here we are today, again, after being bounced around for nearly a decade. Duncan is officially back at the Supreme Court with the CRPA filing their petition early this morning, and I've got a copy of that petition, which is extremely long. Now we know why it took so long for them to file, why they asked for so many extensions. Their petition is over 350 pages long. Now we're going to go ahead and check out the first 2 pages of that real quick so you guys get an idea of exactly what they're asking the Supreme Court for. If you guys think that this video deserves a subscribe, consider hitting that subscribe button. Thumbs ups are always appreciated, and that will help us expand, grow, and help more people find videos like this. So with that being said, let's go and take a quick look at the petition. So for everybody who was waiting, here it is right here. In the Supreme Court of the United States, Virginia Duncan, Richard Lewis, Patrick Levitt, David Marguglio, Christopher Waddell, and the CRPA, petitioners against Rob Bonta in his official capacity as Attorney General of the state of California. This is the petition for writ of certiorari. Now, in order to keep this video from being 5.5 hours long, we're just going to read the question presented because, again, this petition is 356 pages long. So here in the question presented, it says, this court held in D.C. v. Heller that states may not ban arms that quote-unquote law-abiding citizens typically possess for lawful purposes. And it reiterated in NYSRPA v. Bruin that the Second Amendment protects the possession and use of weapons that are in common use at the time. California nonetheless persists in banning feeding devices capable of holding more than 10 rounds of ammunition, even though tens of millions of law-abiding Americans have long lawfully owned hundreds of millions of these devices as integral components of legal firearms. Adding insult to injury, California's ban applies retrospectively, requiring citizens to dispossess themselves of lawfully acquired property without any compensation from the state. This court previously GVR'd in light of Bruin, but rather than follow this court's marching orders, a divided en banc panel once again upheld the ban. In doing so, the Ninth Circuit not only doubled down on its pre-Bruin precedent, but it reached the remarkable conclusion that California's sweeping ban on common arms does not even implicate the Second Amendment. The questions presented here are, 1, whether a ban on the possession of exceedingly common ammunition-feeding devices violates the Second Amendment, and 2, whether a law dispossessing citizens without compensation of property that they lawfully acquired and long possessed without incident violates the taking clause. So you can see right there, there's actually 2 questions. You have the Second Amendment question and you have the taking question. The reason the taking question is there is because in California there was a grandfather clause. So people that own magazines that can hold more than 10 rounds, that owned them prior to the initial ban, were allowed to keep them. They were allowed to possess them, they were allowed to use them, they were allowed to have them, they were fine and free, right? That's why I call the grandfather clause a grandfather scheme, is because it can get pulled away at any time, and that's exactly what California did. When California updated their ban, they essentially went back and preemptively said, okay, everything that we said you could own up until this point, we're changing our minds, we're going back on that. You're going to have to give them up, destroy them, turn them in, or send them out of state, whatever. You're not going to be allowed to have them anymore in the state of California. There was nothing about compensation on there. It's either destroy them, turn them in, or we take you to jail. That's what California did with their, grandfather clause, and why it caused so many problems. Now, I personally think Duncan is the best magazine ban case that we have ever seen go before the Supreme Court. The reason for that is this is a case that is finished. It's not an interlocutory case like Ocean State Tactical was. This is a case that has been completed. It's already been GVR'd by the Supreme Court once, post-Bruin. And what actually might help us out is the fact that the Ninth Circuit showed absolute disdain for the Supreme Court's Bruin decision and did everything they could to simply work around it, because the Supreme Court said if the Second Amendment is implicated, you have to look at our nation's history and tradition of firearms regulation to find something that is historically relevant and similar to the law as it stands today if you want to be able to uphold it. California is not able to do that. They know that they're not able to do that, so what's one way to get around it? By simply saying that they're not protected by the plain text at all. Then you don't even have to go to the next step. Even if they do kind of answer some of the questions in the next steps, there is no relevant historical analog for a ban as it stands today. There is nothing out there that says, oh, we're just going to have some politician somewhere, right? Some bureaucrat probably come up with some arbitrary 10-round number, and we're going to somehow make that stick across the country. And as of right now, we have a patchwork of different laws in different states. It might be 15 in one, 10 in another, 20 in another. Who knows? And as you make your way across this country, you could be going through different zones where the laws could be completely different. And so this would get rid of that. This would say that these are protected by the Second Amendment, if the Supreme Court rules in our favor, obviously, which I think that they should. But this would basically get rid of that. It would get rid of that patchwork and say that magazine capacity bans are, in fact, unconstitutional. So, again, I think this is the best case that has been before the Supreme Court that deals with this specific topic yet. Now, will they take it? That's probably the big question that everybody has down in the comment section. I'm sure you guys have been typing for a while now. And the answer is, who knows? With the Supreme Court. But we do at least have Kavanaugh on record saying that he believes that the Supreme Court will take one of these cases in the future. So the fact of the matter here is that all magazine bans nationwide, regardless of the capacity limit, are unconstitutional. It's very clear, it's very plain and simple when it says shall not be infringed. You know, you can't have a politician or a bureaucrat come up with some arbitrary 10-round number and then just have it stick amongst all these different states. Even though, as of right now, there's a patchwork of different limits. So you could go from one state where you can keep whatever you want, standard capacity, right, or even higher. You can go to another state where it's 15 and then another state where it might be 10. This would clarify all of that and get rid of these bans across the country. So this is definitely one that they need to take. This is a question that needs to be answered. Both of the questions that have been presented here need to be answered. But this is a very big deal. So the Supreme Court, once they get back in session in October, they're going to start their conference process, right? That's when all the Supreme Court justices get together. They look over all the different cases that sit before them and decide what they're going to do with them, whether they GVR them or they decide to simply deny them or accept them. That's what they do during the conference process. So we're going to have to wait until they're back from session to see when the first conference for Duncan will be. But I'm hopeful. I'm trying to remain optimistic that they'll take it. Again, this is something that needs to happen, because if it doesn't and California's law is allowed to stand, you're talking about millions of people who would essentially become criminals overnight. So anyway, I just want to let you know about that. It's great news, huge news for the weekend. Duncan is now officially at the Supreme Court. Thank you all very much for watching. I do appreciate it. Y'all have a great day.